Chapter 10. Parties to Crimes. Section 160. Classification. At common law, parties to crimes constituting felonies are classified as follows. 1. Principals in the first degree. 2. Principals in the second degree. 3. Accessories before the fact. 4. Accessories after the fact. In treason and in misdemeanors there are no accessories. All who participate criminally in these offences are guilty as principals. Section 161. Principal in the first degree. Definition. A principal in the first degree is a person who actually commits the crime himself, or commits it through an innocent agent. In the latter case, although absent, he is said to be constructively present. The innocent agent may be animate or inanimate. Section 162. Animate innocent agent as principal. The agent who commits the act may be innocent because of ignorance, youthfulness or insanity. If A procures B, an idiot or lunatic, to kill C, A is guilty of the murder as principal, and B is merely an instrument. The method of killing is immaterial. Thus in some cases a man shall be said, in the judgment of the law, to kill one who is in truth actually killed by another, as where one incites a madman to kill himself or another, lets out a wild beast, or employs a madman to kill others, whereby any is killed. There is principle in this case, though absent, because the instrument cannot be a principal. Thus, where an officer is endeavoring to arrest an insane person, and a third person frees the lunatic's hand from the grasp of the officer, thereby enabling the lunatic to shoot and kill the officer, the third party is criminally liable for the lunatic's act. Section 163. Principle of constructive presence based upon necessity. The principle of constructive presence is said to be founded upon necessity, since it is said that there could be no principal in a crime unless he is present when it is committed. In cases where the crime is committed through an innocent agent when personally absent, the presence of the agent is held to be constructive presence of the principal. Section 164. Moral innocence of agent not the test in first degree. Whether the real instigator of the crime is an accessory before the fact or a principal in the first degree, does not depend upon the moral innocence or guilt of the agent, but upon the presence or absence of criminal liability on his part. Thus, it has been held that one who procures an instrument for a woman, which he advises and directs her to use upon herself to produce a criminal abortion, may be convicted as principal, where the woman, pursuant to such advice and direction, uses the instrument for such purpose, though in the absence of the former, thereby causing her to miscarry and die. Section 165. Principal and innocent agent in different jurisdictions. The fact that the principal and the innocent agent are in different jurisdictions at the time the crime is committed is immaterial. Personal presence, at the place where a crime is perpetrated, is not indispensable to make one a principal offender in its commission. Thus, where a gun is fired from the land which kills a man at sea, the offence must be tried by the Admiralty, and not by the common law courts, for the crime is committed where the death occurs, and not at the place from whence the cause of the death proceeds. And on the same principle an offence committed by firing a shot from one county which takes effect in another, must be tried in the latter, for the crime was committed. In such cases the offender is an immediate actor, in the perpetration of the crime, although not personally present at the place where the law judges it to be committed. He is there, however, by the instrument used to effect his purpose, and which the law holds sufficient to make him personally responsible at that place for the act done there. But crimes may be perpetrated through the instrumentality of living agents in the absence of the principal, and our law books are full of such cases, where poison is knowingly sent to be administered as medicine, by attendants who are ignorant that it is poison, and death ensues. The person who thus procures the poison to be taken is guilty of murder. So where a child without discretion, an idiot or a madman, is induced by a third person to do a felonious act, the instigator alone is guilty, and although not present at the perpetration of the crime, he is a principal felon. 10. Section 166. Separate acts pursuant to common design as test of principal in first degree. Where, pursuant to a common criminal design, separate acts are done by different persons in the absence of each other, all are guilty as principals. The basis of this rule is necessity, for if the rule were otherwise none of the parties could be convicted. If several persons conspire to commit a forgery, and in pursuance of the conspiracy they make distinct parts of the forged instrument in the absence of some of their number, the forgery being completed by one of them adding the signature in the absence of all the rest, all are guilty as principals. It is to be observed, however, that at common law forgery is only a misdemeanor, and that in misdemeanors all accomplices are principals whether absent or present. By statute, however, forgery is made a felony, and the rule as stated is applicable to statutory forgery. Section 167. Principal in the second degree definition. A principal in the second degree is a person who is present, either actually or constructively, when a felony is committed by another, and who aids or abets in its commission. Blackstone says, a principal, in the first degree, is he that is the actor, or absolute perpetrator, of the crime, and, in the second degree, he who is present, aiding and abetting the fact to be done, which presence need not always be an actual and immediate standing by, within sight or hearing of the fact, but there may be also a constructive presence, as when one commits a robbery or a murder, and another keeps watch or guard at some convenient distance. Section 168. Essential elements of principal in second degree. To constitute a person a principal in the second degree, the following conditions must exist. 1. There must be a guilty principal in the first degree. 2. The principal in the second degree must be present, either actually or constructively, when the felony is committed. 3. He must aid or abet in the commission of the felony to the knowledge of the former. Section 169. The first condition of principal in second degree. To have a principal in the second degree, there must be a principal in the first degree, who actually commits the criminal act. It requires no aid from the act of the principal in the second degree to complete the guilt of the principal in the first degree. But the principal in the second degree cannot be guilty of crime if the principal in the first degree fails to do his part, even though the principal in the second degree has performed his part. Section 170. The second condition of principal in second degree. To constitute a person a principal in the second degree, he must be present when the felony is committed. A constructive presence, however, is sufficient, but it is essential that he be near enough to render some assistance if needed. It is also essential that his purpose in being present must be to render aid to the chief felon, and the latter must have knowledge of this fact. It is to be observed, however, that it is possible for a person to be constructively present and at the same time be many miles away, and in a different county. Thus, where several persons conspired to commit a stage robbery, and pursuant to the conspiracy, one of them built a fire on a mountain 40 miles away and in a different county, to give the others notice of the whereabouts of the stage at that time, he was held guilty as a principal in the second degree. If several unite in one common design, to do some unlawful act, and each takes the part assigned to him, though all are not actually present, yet, all are present in the eye of the law. Thus, where several persons conspire to burglarize a store, and, to facilitate the burglary and lessen the danger of detection, they agree that one of them shall entice the proprietor away from the store in which he usually sleeps, to a party about a mile distant, and detain him there while the other confederates burglarize the store, and the conspiracy is carried out. The one who thus entices the proprietor away and detains him is constructively present, and guilty as principal in the second degree. And where a person, pursuant to a preconcerted plan, devised by himself, remains downstairs in his own home while his confederate above steals money from a lodger and brings it downstairs and delivers it to him, he may be convicted of the larceny as a principal. Section 171. The third condition of principal in second degree. For a person to be a principal in the second degree, he must aid or abet in the commission of the felony. One who by chance comes upon the commission of a crime and looks on but does not assist is not a principal in the second degree. Some overt act is necessary. The law does not reach mental operations unaccompanied by any action or language. Presence and mere mental approval are not sufficient to render a person guilty, as principal in the second degree. On the other hand, actual physical aid is not essential to constitute a person a principal in the second degree. It is enough that he was ready to assist if required. Section 172. Practical distinction between principal in first degree and principal in second degree immaterial. Practically speaking, there is no distinction between a principal in the first degree and a principal in the second degree. Both are equally guilty. So if one be indicted as principal in the first degree, proof of his presence, aiding and abetting another in committing the offense, although not actually himself doing it, will support the indictment, and if indicted as principal in the second degree, proof that he committed the crime will support the indictment. Section 173. Aider and abetter. Definition. Technically speaking, the term aider and abetter is applicable only to a principal in the second degree. To constitute a person an aider and abetter, he must be present, either actually or constructively, but he must not be the main actor in the commission of the crime. He is a person who watches to prevent his confederates from being taken by surprise, or stations himself at a convenient distance to aid them in escaping, if necessary, or is so situated as to be able readily to go to their assistance. Thus, where one of several confederates leads a girl's escort away in order that his companions may rape her, and they commit the crime, he is constructively present and an aider and abetter. Section 174. Accessory before the fact. Definition: An accessory before the fact is a person who counsels, commands or procures the commission of a felony by another, but who is not present, either actually or constructively, when the felony is committed. Section 175. Essential elements of accessory before the fact. To constitute a person an accessory before the fact, the following conditions are essential. 1. There must be a guilty principal in the first degree. 2. The accessory must not be present when the felony is committed, either actually or constructively. 3. The accessory must participate in the commission of the felony. Section 176. First condition of accessory before the fact. The felony must be committed by a guilty agent. This agent will constitute a principal in the first degree. Where a felony is committed through an innocent agent, there is no accessory before the fact. To sustain an indictment against a person charged as an accessory before the fact to the commission of a felony, the prosecution must establish the guilt of the principal felon. This, however, cannot be done by confessions of guilt of the latter, since as to the accessory, such confessions are mere hearsay. Such confessions might be used, however, against the principal himself. Section 177. Second condition of accessory before the fact. To constitute a person an accessory before the fact, he must be absent when the felony is committed. Presence on his part, either actual or constructive, renders him a principal if he participates in the crime. One who procures another to take and carry away gold, but has no part in the taking or carrying away, is not a principal, but an accessory before the fact. Section 178. Third condition of accessory before the fact. It is also essential, to constitute a person an accessory before the fact, that he participate in the commission of the crime, by counseling, commanding, advising or procuring it to be done. Mere mental approval, or bare permission, is not sufficient, as said by Sir Matthew Hale, and therefore, words that sound in bare permission, make not an accessory, as, if A says you will kill J.S., and B says, you may do your pleasure for me, this makes not be accessory. Nor is mere knowledge that the crime is to be attempted, sufficient. It is not essential, however, that the procurement be direct. It may be through the agency of another. Moreover, the person employed by the agent to commit the crime may be wholly unknown to the accessory. But if the accessory order or advise one crime and the principals intentionally commit another, as where he abets the robbery of a safe, but the principals rob a person, the accessory is not answerable. Section 179. Accessory after the fact. Definition. An accessory after the fact is a person who receives, relieves, comforts or assists a felon personally, with knowledge that the latter has committed a felony. Section 180. Essential elements of accessory after the fact. To constitute a person an accessory after the fact, the following conditions must exist. 1. A completed felony must have been committed when the felon receives relief or assistance. 2. Relief or assistance must, according to some decisions, be furnished to the felon personally. 3. The person who gives relief or assistance to the felon must have knowledge at the time he does so of the felon's guilt. Section 181. First condition of accessory after the fact. The person who receives the relief or assistance must have committed a felony, and the felony must be completed at the time the relief or assistance is rendered. Thus, a person is not an accessory to the crime of murder where the victim dies after the felon receives the relief or assistance. Until such felony has been consummated, any aid or assistance rendered to a party, in order to enable him to escape the consequences of his crime, will not make the person affording such assistance guilty as an accessory after the fact. Section 182. Second condition of accessory after the fact. Actual relief or assistance must be furnished, and it must be rendered to the felon personally. As a general rule, any assistance which may hinder his apprehension, trial, or punishment, is sufficient. Thus, concealing him in the house, or shutting the door against his pursuers, to enable him to escape, taking money from him or supplying him with money, a horse, or other necessaries, for the same purpose, conveying to him instruments to enable him to break prison, or bribing the jailer to let him escape, is sufficient. On the other hand, merely suffering the principal to escape, or agreeing for money not to prosecute the felon, or having knowledge that a felony has been committed and failing to make it known, is not sufficient. The relief or assistance given must, as heretofore stated, be rendered to the felon personally. As said in an English case, to substantiate the charge of harboring a felon, it must be shown that the party charged did some act to assist the felon personally. It has been held, however, that where a person employs another to harbor the principal felon, the employer may be convicted as accessory after the fact, though he himself did no act of relieving, and furthermore, that he may be convicted on the uncorroborated testimony of the party who actually did the harboring. And some recent cases hold that one who destroys the incriminating evidence of a felony may be an accessory after the fact to such a felony. Where a person is charged as accessory after the fact to a murder, The question for the jury is, whether such person, with knowledge of the felony, either assisted the murderer to conceal the death, or in any way enabled him to evade the pursuit of justice. Section 183. Third condition of accessory after the fact. Knowledge of the felony, at the time the relief or assistance is rendered, is essential to constitute the aider an accessory after the fact. Mere knowledge alone without giving information to authorities does not make one an accessory after the act. It seems that actual knowledge is required, and implied knowledge from general notoriety will not be imputed upon an indictment against a party as an accessory after the fact in robbery. Proof of the prisoner's knowledge of the felony, together with proof of his aiding the principal in disposing of the fruits of the robbery, is sufficient evidence of comforting and assisting to support the indictment. Section 184. Basis of criminal liability of accessory after the fact. An accessory after the fact is held criminally liable on the ground that the assistance he renders the felon constitutes an interference with public justice, in that it tends to facilitate the escape of the felon. Section 185. Parties incapable of being accessories after the fact. At common law, a wife has capacity to be an accessory before the fact to her husband as principal, but not to be an accessory after the fact to her husband as principal. The husband, however, has capacity at common law to be accessory either before or after the fact to his wife as principal. In some states, by statute, certain persons other than a wife are incapable of being accessories after the fact to certain other persons as principals. Thus in Illinois, a husband, wife, parent, child, brother or sister to the offender cannot be held as an accessory after the fact at common law. However, as stated by Blackstone, so strict is the law that the nearest relations are not suffered to aid or receive one another. If the parent assists his child, or the child his parent, if the brother receives the brother, the master his servant, or the servant his master, or even if the husband relieves his wife, who have any of them committed a felony, the receivers become accessories. But a feme covert, however, cannot become an accessory by concealing her husband, for she is presumed to act under his coercion, and therefore she is not bound, neither ought she, to discover her lord. Section 186. Distinction between principals and accessories before the fact abolished. In some states, among them Illinois, the distinction which existed at common law between principals and accessories before the fact has been abolished by statute. Thus, the Criminal Code of Illinois provides, an accessory is he who stands by, and aids, abets or assists, or who, not being present, aiding, abetting or assisting, hath advised, encouraged, aided or abetted the perpetration of the crime. He who thus aids, abets, assists, advises or encourages, shall be considered as principal, and punished accordingly. Section 187. Mode of indictment of accessories before the fact. At common law, a principal must be indicted as such, and an accessory as such. If the participant is a principal, though of the second degree, he cannot be charged in an indictment as accessory. If he is an accessory, he cannot be held as principal. It is to be observed, however, that it is possible for a person to be both a principal and an accessory to the same felony, or an accessory before the fact and an accessory after the fact to the same felony. Where the distinction between principals and accessories before the fact has been abolished by statute, as in Illinois and several other states, accessories before the fact are indicted as principals. In Illinois it is held that they must be so indicted. Thus, where an indictment charges that three persons, named, with a stick of wood which each severally had and held in their several right hands, inflicted a mortal wound, causing death, proof that either one of them struck the fatal blow with the weapon described, and that the others were accessory to the fact, will be sufficient to sustain a conviction of all three as principals. There is no variance in such case between the allegations in the indictment and the proof. Section 188. Order of trial of accessory before the fact. Rule at common law. Rule by statute. At common law, an accessory before the fact cannot be put upon trial, without his consent, until after the conviction of the principal. This is owing to the fact that were the rule otherwise, as declared by Blackstone, it might so happen that the accessory should be convicted one day, and the principal acquitted the next, which would be absurd. Where, however, the accessory is indicted with the principal, he may waive his right to have the principal tried first and be tried jointly with him. In England, as well as in some of the states of this country, the common law rule relating to this matter has been changed by statute. The English statute provides that persons who shall counsel, procure or command any other person to commit a felony shall be deemed guilty of a felony, and may be indicted and convicted, either as accessory before the fact to the principal felony, together with the principal felon, or may be indicted and convicted of a substantive felony, whether the principal felon shall have been convicted or not. Section 189. Accomplices definition, criminal liability. An accomplice is a person who participates in the commission of a crime, either as a principal or as an accessory, with criminal intent. The participation requisite, however, must be something more than mere passive consent. As heretofore stated, consent which amounts only to mere mental approval is not sufficient. On the other hand, an accomplice is criminally liable for all criminal acts in which he actively participates, and where several parties conspire or combine together to commit any unlawful act, each is criminally responsible for the acts of his associates or confederates committed in furtherance or in prosecution of the common design for which they combine. When several persons conspire together to invade a man's home, and go there armed with deadly weapons for the purpose of attacking and beating him, and, in the furtherance of this common design, one of them gets into a difficulty with him and kills him, the others being present, or near at hand, they also are guilty of murder, although they did not intend to kill. And if a third party espouses the cause of one of two parties to a fight, into which he enters to help whip the other party, he is criminally liable for the death of such party, whether caused by a blow given by himself, or by one given by the surviving party, or from both combined, and the criminal intent of such volunteer may be inferred from his conduct. But, where one party, in an altercation with another party, knocks the former down, whereupon a mere bystander kicks the person knocked down, and the latter dies as a result of the kick, the party who knocks the victim down is not criminally liable for his death. The reason is he does not volunteer, in such case, in another's cause, while on the other hand, the bystander volunteers in his own behalf without request or expectation. Section 190. Accomplices. Act done must be the natural and probable consequence of the conspiracy. If two persons conspire to commit a felony, and while they are engaged in prosecuting that common design one of them commits murder, the other also is guilty of murder. Thus, where a wife conspires with her husband to commit a robbery, and while both are so engaged he commits murder, the wife also is guilty of murder. The act done, however, must grow out of the conspiracy. In other words, it must be the natural consequence of it. Moreover, it must occur before the conspiracy is abandoned. It is not necessary, however, that it be intended as a part of the original design if it be the ordinary and probable result of the wrongful act specifically agreed on, so that the connection between them may be reasonably apparent, and not a fresh and independent product of the mind of one of the confederates, outside of, or foreign to, the common design, but a charge which requires proof of an express agreement to do an unlawful act before the defendants would be guilty of a conspiracy, ignoring the evidence which tended to prove that they were all present, or near at hand, when the homicide was committed, encouraging its perpetration, is misleading if not erroneous, and is properly refused. Where several persons join in the commission of a crime, and, in attempting to escape, one of them commits a homicide, those who do not consent to the act, and who are not privy in fact, cannot be held criminally liable by reason of the original combination. There can be no criminal liability on the part of one who is not himself engaged in the act of his associates, unless it is within the scope of the combination to which he was a party, and thus authorized as his joint act. The principle is analogous to that of agency where the liability is measured by the express or implied authority. So where two steal property and are trying to dispose of it after carrying it away some distance, and an officer attempts to arrest them because they had stolen property in their possession, and one, in resisting arrest, shoots the officer, his companion cannot be held for the shooting. And where several men combine for the purpose of inducing a girl to go to a shop for the purpose of prostitution, and they induce her to go there, and all have sexual intercourse with her there, and, in order to avoid arrest or exposure, one of the conspirators, against the consent of the others, throws the girl out of a window, without any intention of killing her, but which causes injuries of which she dies, the others are not criminally liable for her death. Section 191. Principal and agent. A principal is criminally liable for the criminal acts of his agent committed within the scope of the agency. In other words, a principal is criminally liable for criminal acts of his agent which the former expressly or impliedly authorizes to be committed, but not for an act which he has expressly forbidden. On the other hand, a principal is not criminally liable where he ratifies an unauthorized criminal act of his agent. In the law of contracts, a posterior recognition, in many cases, is equivalent to a precedent command, but it is not so in respect to crimes. The defendant is responsible for his own acts, and for the acts of others done by his express or implied command, but to crimes the maxim, omnis rati habitio retratra habituret mandata priori equiparata, is inapplicable. The agent himself is always liable for his criminal acts. The fact that he does the act for another will not excuse him, and it is immaterial that he is a mere volunteer and receives no compensation for the act. The rules applicable to principal and agent are also applicable to master and servant.